Hello, and thank you for joining me for Colorado HR Rules to Know for 2021. This is being presented by the Larimer County SBDC and will be available on demand on their website so that you can refer back to it as many times as you would like. I am your trainer today. My name is Tina Todd, and I'm a certified HR professional with Simply HR here in Northern Colorado. Again, I'm a certified professional, not an attorney, so I cannot give you legal advice. And also, this training should not be considered legal advice. If you have specific questions, you can certainly ask an HR professional about best practices or the rules. If you need legal advice, please contact the SBDC and they would happily get you in touch with someone. We are going to be going over many things that Colorado has enacted over the last year, and this is our list of things. So I will go ahead and jump right in. It was a busy year in 2020, besides the very obvious reasons. First off, we'll talk about Colorado overtime and minimum pay standards, also referred to as comps. So Colorado has sets of wage and hour orders, and they tend to change these not every year, but it has been every year for the last couple of years. And it has all of the rules for employers with employees in Colorado. To start with, for non-exempt employees, so employees who are not exempt from minimum wage or overtime, those non-exempt employees must be paid $12.32 per hour as a minimum or $9.30 per hour as a tipped employee. That is the cash wage that's required. Now, employees just have to reach these averages over the course of the work week. And for tipped employees, we are assuming that they are going to make up that 302 in tips. So for tipped employees, you have to average out how much the employee made through both the cash wage provided by you, the employer, and tips. And they also have to make at a minimum $12.32 per hour for all hours worked in every single work week. That became effective in January 2021. In addition, Colorado employers have overtime obligations, which are over and above the federal rules. So there are 3 triggers in the state of Colorado. So employers must pay 1.5 times an employee's regular rate of pay for all hours worked over 40 in a work week, over 12 hours in a work day, or if an employee works over 12 consecutive hours, then that employee should be earning time and a half their regular rate for anything over and above those triggers. Another requirement now with the Comps 37 is that employers must post and distribute a comps order poster. This requirement came out in March and then in April of 2020. So it's not surprising that most of us didn't get the memo. So if you have not been doing that, I would just suggest notifying your employees now. Go ahead and print the notice. And Colorado is requiring that employers receive an acknowledgement for receipt of this notice. So go ahead and print this on the colorado.gov site under the posters page, and then get your employees to sign a document saying they have acknowledged receipt of the Comps Order 37 poster. One more thing to note that has changed in the comps order is there is now a break penalty. So for non-exempt employees, employees must receive a 10-minute break for each 4 hours approximately. And if employees are not given that break, then the employer must pay the employee for 10 minutes at the end of the shift for each break that was missed. So in addition to increased productivity and decreased safety incidents, now a penalty is another great reason to make sure your employees are receiving their scheduled breaks according to the law. So I have included a copy of the comps poster and notice so that you can see it here. And again, this is available on colorado.gov. If you're not familiar with it, I would also highly recommend that owners and managers take some time to really read through this so that you can familiarize yourself with all of the requirements for exempt and non-exempt employees in the state of Colorado. And it's important to note that these rules apply to Colorado-based employees. If your company is headquartered somewhere else, but you have an employee in Colorado, these rules apply. If your business is located in Colorado, but your employee is working remotely in another state, which is becoming a much more common practice, of course, then the state where the employee is located is where you will have to find employment laws and rules that will apply to that particular employee. And oftentimes, it's not just the state you'll need to look up, but you will also need to look at county, city, and other jurisdiction, as some of those have very specific rules based on where the employee is physically working from. Okay, back to the comps notice. Something else that is new for 2021 is the salary threshold for exempt employees. So again, non-exempt employees have minimum wage. Exempt employees also have a minimum salary that they must be paid. And it is a very common misconception that all it takes is an employee to be paid a salary and they are automatically exempt from minimum wage and overtime. The reality is there is a list of duties or tasks that the employee must be fulfilling in addition to a minimum salary requirement before they are considered exempt. So in other words, employees are considered non-exempt. You must track their hours, pay them minimum wage and overtime, unless you can prove they are exempt from those requirements. In order to be exempt, they should pass tests through both the state of Colorado, which can be found in the full comps requirements, along with the test in the Department of Labor or Fair Labor Standards Act Fact Sheet 17A. We don't have time to dive into all of the details here in this training, but know they are quite lengthy and you'll want to be very thoughtful and careful about determining if your employees are exempt or non-exempt. This is something I would highly recommend speaking to an HR professional or an attorney about to be sure you are classifying employees correctly and not underpaying someone who should be making overtime. And again, they have to pass all criteria, and typical categories are executive, professional, administrative, and outside sales exempt. There are a few other categories of exempt employees, but those categories are more narrowly defined and not as often used. However, business owners, somebody who owns 20% or more of a business, is also automatically exempt. So, fortunately, the government doesn't care if us business owners make minimum wage or are paid overtime or not. Okay, so with that, the minimum salary for Colorado exempt employees is now higher than the federal test. Last year in 2020, we were consistent with the federal requirement of $684 per week. However, in 2021 and every year after this for the next several, we have increases of about $5,000 per year. So in order to be considered exempt from minimum wage and overtime, employees in Colorado must be paid at least $778 per week, and they must be fulfilling certain functions or duties as outlined in the comps order and in Fair Labor Standards Act Fact Sheet 17A. Again, this is one you might want to partner with an HR professional on to be sure that you're understanding all of the requirements and to make sure that your employees are being classified correctly. Okay, Another huge piece of legislation for 2020 was the Equal Pay for Equal Work Act. This became effective in 2021. This prohibits employers from discriminating on the basis of sex by paying employees um, or different sexes differently for similar work. So the act requires an employer to announce to employees all advancement opportunities or promotional opportunities, and employers must post and announce the pay range for openings. It's required to post a good faith estimate of the pay range. Employers now also have to have job descriptions for each job title, and employers will have to hang on to those job descriptions and wage rate history through the course of employment and for 2 years after employment ends. On applications, a requirement for equal pay for equal work says that you may no longer ask how much somebody has been paid at their previous jobs. So if you have that on an application, or if you have it as a standard practice in interviews or in reference checks, please take those questions out of those places. And you can, however, ask during the screening process or during interviews how much somebody would like to make. You can ask if they have a minimum salary requirement or if they have an ideal salary that they would like to make. You just can't ask what they were paid previously. The idea behind this is if they were underpaid for a position before, you could be perpetuating a pay disparity unintentionally because you might adjust pay down for somebody who was underpaid before. While we're discussing applications, I'll just mention that Ban the Box was effective in Colorado beginning September of 2019. So this box refers to the box that asks if anyone has a previous conviction. So you cannot have a blanket disqualification in the state of Colorado, with some exceptions, of course, like everything. However, for the most part, employers cannot have a blanket disqualification for anyone who is convicted of a crime in the state of Colorado. You can, however, ask this question towards the end of the first interview. That's the best practice. And you can also let employees know that they will be, or applicants know that they will be subject to a background screening by applying and being considered for a certain position. And that may weed out some applicants if you do truly have some requirements set forth by licensing agencies or insurance. For job descriptions for equal pay for equal work, there's several pieces that we recommend having included. In order to get to this, you'll first have to do a job analysis. You'll need to determine the knowledge, skills, and abilities, so KSAs, required for a job. You'll want to look at physical characteristics and environmental factors, and credentials or experience that are required. By that, we're considering, is there a hot or cold working environment? Is it loud? Does somebody physically have to stand, navigate uneven surfaces? There's so many things to consider, and we highly recommend having all those physical requirements included, as well as what criteria you would like to see. I would also encourage you to truly consider the minimum barrier for entry. If it says that you must have 10 years of experience as a manager, but you would actually consider someone who has 3 years of experience, then let's be honest and bring that job requirement and job analysis down to what it actually is, which would be 3 years. You'll need the essential functions. So what are the minimum essential things that somebody needs to do this job effectively? You'll want to organize that data. Job descriptions can easily be put into a nicely organized format. And some things you can include are obviously the job title, their classification as exempt or non-exempt, their pay range. So what is the true minimum and maximum that somebody in this role could be making? You want a summary, again, those essential functions and all of those things we talked about. In addition, we like to see statements that include your equal employment opportunity statements and at will to outline that jobs are not contractual in the state of Colorado or for you, but employment is at will or voluntary, and the employee and employer can choose to separate at any time, unless, of course, there is a contract stating otherwise. You'll also want to add a disclaimer to say that the job description is not an all-inclusive list, and other duties may be assigned, because there's always that employee that says, well, I don't have to do this one thing because it wasn't in my job description. You'll also need to have signature lines so that you can have the employee or applicant even sign that job description, indicating they understand and they agree they can fulfill all of those duties. And then lastly, again, Colorado is requiring that you have a job description for each position. So once you have this document created, you can use this document for the job posting. I would refer back to it during the interview process. If somebody needs an accommodation, you can look at it. And we highly recommend revisiting this to make sure, one, it is current and up to date during the time of performance evaluations or reviews, but also you can use this as a benchmark to see if your employees are meeting all of the expectations that you agreed upon. Then lastly, we have to include pay ranges. So again, you'll look at job analysis. Oops, sorry, wrong direction. You will look at job families. If you have a large organization, you can group some pay ranges. You'll likely want to do some market research. Some resources for that information are salary.com, BLS, so the Bureau of Labor Statistics.org. You can also look at ONET, and many organizations, insurance companies, payroll companies, HR firms provide some third-party software that can help you with that too. And you can create job grades, again, if you have a larger organization and you can group jobs. And then salary ranges. You'll want to establish the minimum, midpoint, and maximum pay range for each job title at your organization. The most common practice is to use a 30 to 40% range between the top and bottom salary. However, there's actually not a requirement on how broad that range is. Generally, entry-level positions tend to have a more narrow pay range, and higher level C-suite type positions tend to have a much more broad pay range. And then you'll of course want to update those ranges and consider changes to cost of living and also any additional duties or changes to those jobs as you go about the day-to-day tasks of work. This is a sample pay scale so that you can just easily see how or what this might look like. So oftentimes an employer will come up with a middle salary or middle pay rate and sort of calculate from there. So if you were to do a 30% salary range, the top grid is an example of that. So you could take, just as an easy example, somebody who's making $25 per hour. You multiply it by 0.85 to take away 15% to get the bottom of that salary range or pay scale. And then you'll multiply it by 1.15 to get the top end of that 30% salary range. And then the bottom goes through that same process, but with a 40% salary range. Okay, so that wraps it up. That is a very brief overview of equal pay for equal work. It is very extensive, and I would really consider when you have promotional opportunities, the definition of that is very, very broad. So by creating a senior level job title or just a new job title in general, you are most likely creating a promotional opportunity, which will have to be posted and follow all of the rules that we've just talked about. Again, take partners with your HR friends, with your attorney friends to make sure you're covering all the bases there. Moving on, We'll look at Public Health Emergency Whistleblower Act. So this became effective mid 2020. And what is interesting about this one is that it does not just apply to employees, but this applies to workers in the state of Colorado, which includes independent contractors, of course. So this prohibits any type of adverse action, discrimination, or retaliation against any worker who in good faith raises any reasonable concern about workplace violations of health and safety rules related to a public health emergency. So, in other words, if an employee approached a manager or approached a government official about health and safety concerns related to the pandemic at your workplace, then your organization cannot retaliate against that individual for bringing forward that good faith complaint or concern. Hopefully, they have spoken to your internal team first, and hopefully, you are a good recipient of suggestions and follow up with employees so they do keep that feedback internal first. But this does highlight that they are protected if they take it to an external organization. Something to consider for this is you may want to add a statement in your handbook, likely in the whistleblower protection, to acknowledge that you are aware and abide by this particular requirement. Okay, next we had the Healthy Families and Workplaces Act, and there were three parts of this particular act. So part one was emergency paid sick leave, which you can see expired on December 31st of 2020. So I'm not going to spend any more time discussing that one. I'm also going to go out of order intentionally. So part three is public health emergency leave. So this provides time off for employees if they should need it in the event of a public health emergency. This requires an employer to supplement an employee's paid sick time or paid time off so that the employee has access to 80 hours for a full-time employee or a 2-week average for a part-time employee. This requires that employees can use their paid time off or paid sick time first, but if they need additional time off to cover 2 weeks for a public health emergency related reason, such as COVID, then the employer must supplement the difference so the employee has access to that. Okay, last I will discuss, I should mention that this is effective for 30 days after the end of a declared public health emergency. So the last time I checked, and I am recording this on June 16th, so the last time I checked, the public health emergency was extended on June 11th. It will go through July 11th. And this is effective for 30 days after that. So it will be effective for at least until August 10th. But again, may be extended beyond that. Okay, part two of Healthy Families and Workplaces Act, I'm putting last because this is one part that does stick with us for a much longer time. So for January 1st, 2021, employers with 16 or more employees must begin to comply with this already. And if an organization has 15 or fewer employees, they will have to comply with this on January 1st, 2022. And employees must accrue at least 1 hour of paid sick and safe time for every 30 hours worked. So that is an hourly accrual of 0.0333 per hour worked. And you can cap that accrual at 48 hours per year. For this, accrual must start on the first day of employment. So if you are using a PTO policy to satisfy the requirements, you have to make sure that the accrual rate is at least 1 hour for every 30 hours worked, and you must be sure that accrual starts on day one. For exempt employees, the accrual rate is based on a 40-hour work week, or if they regularly work less than that, you can make it less than 40 hours. And this requires that employees may use the time for what we think of as sort of traditional sick time reasons, as outlined here, and also safe time purposes. So this covers now if an employee was a victim of domestic abuse, sexual assault, or harassment, they may now use that time to obtain mental health or other counseling, seeking relocation services or legal services, also obtaining victim services help, and attending criminal proceedings. So you can see all of the time is very broadened from what we tend to think of paid sick time as. If you were using if you were using an existing paid sick time policy or paid time off policy, again, I would suggest partnering with an HR professional or an employment law firm to be sure that all of the requirements are being met through your existing policy. Okay, another requirement that came about in 2020, I shouldn't say requirement, another piece of legislation is the Crown Act. So this stands for Creating a Respectful and Open World for Natural Hair of 2020. This is something that is becoming much more common across the country, and it prohibits discrimination on the basis of one's race based on an individual's hair texture, hair type, or hairstyle. For example, we have often seen employers make discriminatory decisions based on somebody's hairstyle. So we can no longer discriminate on these particular things. And I know that most employers would not do this deliberately, but we do see it sort of sneak into policies sometimes. So I would encourage you to look at your hygiene policy. And if you have a statement like hair must be neatly combed, then that would go against this particular piece of legislation. And I would suggest taking that out. If you do have a restaurant or an environment where somebody does have to have hair secured, you can of course say that and indicate that hair must be secured or covered. But we don't want to have any policies that say hair must be neatly combed. There are also policies that we've seen that say hair can't extend over 2 inches over the crown of somebody's head. That would go against somebody's natural hairstyle or hair texture in some situations. So we'll want to make sure that that was removed. You can also add a statement in your EEO policy if you'd like to acknowledge that you do not discriminate based on race. And in parentheses, you could say including hairstyles typically or historically associated with race. Again, just acknowledging that you're aware and you do in fact comply with the Crown Act for Colorado. Okay, next we have a Colorado Secure Savings Program. We honestly haven't heard much about it since this was signed July 14th of 2020, but because 40% of private sector workers in Colorado don't have access to a workplace retirement plan, the state has said that they are going to create one, which will be administered by the state. What we've heard is that employees will have access to a Roth IRA account and they can choose to make deposits into that account. And we heard that Colorado was targeting mid-2021 for program implementation, although we have not received many details on it. Next, and lastly, we want to talk about paid medical and family leave. So this was on the ballot. It was Colorado Proposition 118, and this will become effective in 2024. But so you have a heads up now. We do want to address it. We've also been asked lots of questions around it. So this will allow for 12 weeks of paid family and medical leave funded through a payroll tax by employers and employees. So each employer and employee will pay about 0.5% of payroll into a state-administered funds. This will provide an additional 4 weeks of leave for pregnancy or childbirth complications. A covered individual will receive approximately 90% of their weekly wage from the state of Colorado, of course, with a maximum benefit. And this is going to become effective as far as premium collection in 2023, and benefits will be available to employees beginning January 1st, 2024. I do want to mention that this program is in effect for several other states, or some version of this program does exist in several other states, including California, New York, and New Jersey. And I have often, or many times, spoken to employers in those states, and they are genuinely appreciative that this wage replacement does exist for employees. It is almost inevitable that we'll all have to take time off to care for somebody in our family, or to take time off for childbirth and baby bonding. And this provides some form of wage replacement without that huge burden falling upon the employer. So from other businesses I've talked to, they genuinely see this as a positive. So that was a lot of items that came about in 2021. So we've put together a quick to-do list for you. First off, we want to make sure that every job title has a job description that is accurate and current. With each of those job titles and job descriptions, you will need to create a pay scale to address the bottom and top end of what you genuinely believe somebody in that role will make. And then, of course, ensure those exempt salaries meet the exempt threshold requirements for Colorado. Then you'll want to revisit your paid time off or paid sick leave policy if you have them. If you don't have them, now is the time to create them. If you have 15 or fewer employers, you do have until 2022, but it will become effective for all employers at the beginning of 2022. And of course, reach out to your friendly HR consultant friends at the SBDC to help you with that. We'll want to be sure that your EEO and Crown Act policies are addressed to have protections in there related to the Crown Act. You'll want to audit new hire documents and applications to be sure we're not asking about salary history or previous convictions. And you'll want to make sure that they are receiving a copy of the comps notice in addition to the 4 other required documents for Colorado employees when they're going through the onboarding process here. And then, of course, phone a friend if you have questions. There are lots of tax questions in here. We have payroll providers that are able to help answer these questions. Families First Coronavirus Response Act is very much nearing the end, so hopefully we don't have too many questions remaining about that, but it is COVID-related leave. So, of course, if you have COVID-related leave, send a question out to any of us at the SBDC, and we'll be able to get those questions answered for you. But going forward, lots of requirements for Colorado employers, so please make sure that you do ask questions, you do take partners to bring you up to date and compliant so that we avoid any confusion, fines, penalties that could easily happen with all of these requirements. If you would like to get in touch with us, please contact the Larimer SBDC. Their contact information is here, and you can schedule an appointment to meet with one of the HR consultants or other partners who can share information so that you are up to date and your business is compliant. And of course, please tell business friends about the SBDC, whether it is in Larimer County or in their area, so that we can help their business and get them in touch with the resources that they might need. Okay, on behalf of the Larimer SBDC And Simply HR, thank you so much for joining us. And again, we hope to touch base if you have additional questions about what we discussed here today or what I discussed here today or any HR related issues. Thanks so much. Have a good one.